G'day. There's lots of information out there for would-be buyers of management rights businesses, and what we've done in this particular presentation is consolidate the important things from our perspective that we've seen through decades in practice for would-be management rights buyers. The aim is to make sure that you know the basics about what it is you're about to do, how the purchase process works, and educate you around some of the questions that you possibly could be asking when you're looking to buy one of these businesses. So by the end of this, you will know a lot more than before you started, and hopefully will produce an outcome where you're not wasting your time looking at businesses that aren't suitable to you, and you know where and when to go. So enjoy. So when you're looking to buy a management rights business, we get asked a lot about where you actually start. And I suppose through the years, for me, the most important thing to start with is what you actually can afford. Now, what you can afford and what you want to borrow might be two completely different things. So just because a bank might lend you 70%, maybe your personal circumstances are such that you only want to borrow 50. But either way, you need to understand the financial considerations first. Because if you only want to, say, buy a business worth $1 million, there's no point scouting around in the $2 million purchase price category, because that's not where you want to go. So after you know what your financial constraints are, I think it's important to decide what sort of style of business that you want. So that is, are you short stay? Are you permanent? Are you corporate? Are you student? And you've got to figure out from there what your particular personal circumstances are, which will help inform you as to what style of business you want. The next one is location. Now, it's important to understand in management rights that different states have different legislative regimes. Unfortunately, we don't have a national property law regime across the country. So the laws in New South Wales are different to the laws in Queensland. We only practice in Queensland and talk to Queensland clients only. So you need to understand then that where you actually want to be from a physical location perspective becomes pretty important. Do you want to be in Port Douglas? Do you want to be at Rainbow Bay? Do you want to be in Brisbane? So those location questions are then part of the mix, because if you hop online and look around for businesses netting $100,000 that are permanents, you're going to be smashed with opportunities. And part of the issue with management rights, it's not like buying a share or even perhaps an investment unit. You actually want to go and look and see and touch and feel the business that you're looking to buy, because that's the business that you'll be day-to-day hands-on running. So if you've got too many to look at, your bandwidth is simply going to be stretched. So you need to make sure that you narrow down what it is that you're looking for. And then I think the next thing is to try to locate brokers, management rights brokers, specialist people that list properties in that particular region and area and that type of market you're looking for, and link up with them. Because the reality is they're going to be the ones that are more than likely to have the listings that will appeal to what it is that you're looking to buy. And hopefully that then allows you to focus your time on looking at things that you might well buy rather than those that you no chance to get near. So how do you get to know what the management rights industry is all about? Because it's not one of those things where you finish school and you decide you want to be a resident manager. It's an industry that has evolved probably through 50 odd years, starting on Gold Coast in Queensland, to, in a sense, the behemoth that it is today. But it's not very well known in a public sense. So there's a heap of stuff you can do to help you understand what it is that are management rights. And the first thing is to engage with ARAMA. ARAMA is the peak industry body for management rights owners, known as the Australian Resident Accommodation Managers Association. They run regular sessions on getting to know what management rights businesses are about, called the Management Rights Induction Training Program. There's more advanced courses as well if you want to hop into those, but that's certainly the place to start. In Queensland, the body that deals with all strata disputes is called the Commissioner's Office. And they have a spectacular set of resources on their website, including an online course you can do to help you understand what bodies corporate are all about, which includes a component on management rights, but that's very much a big part about what you're doing. The other thing is, from a licensing perspective, if you're going to operate real estate rentals, you're going to need a real estate agent's license of some form. Now, the full license is what you need to run a full-blown real estate agency, but management rights has a special category called a resident letting agent's license. So you absolutely should do that course. And what we say to clients as well is that because you're going to be competing against full real estate agents, if you've got the time and the inclination and of course the money, it's worth going to do the full course so you understand the complete gamut of the real estate industry in Queensland. There's various other forums, seminars, and groups that get together from time to time. You can hook up onto those via Facebook, via Arama, via WeChat, and any range of other ones that you can actually spend time in to help you understand. The other thing, and this is probably one of the best ones, is if you know someone in the management rights industry, spend some time with them. Spend some time with them in their business, seeing what they do, seeing what they deal with from a day-to-day perspective, because that type of knowledge becomes really important then in helping you assess what type of business you actually want to buy. Now let's talk a bit about structuring your management rights purchase. So there's a couple of moving parts to this, and there's a role to play for accountants and there's a role to play for lawyers, but it certainly starts with what you're actually buying. So in most management rights businesses, there's a piece of real estate involved. And quite often, and that's why it's called resident management, you might live in that unit. So from a purchase perspective with respect to the unit, there's a couple of considerations. The first is that if you're going to live there, you get stamp duty relief. You don't pay as much stamp duty for a place you're going to buy and live in as you do for one you invest in and don't live in. The other one is that from a capital gains tax perspective, if and when you sell that unit, your principal place of residence is capital gains tax free. So if you buy it for 100 and sell it for 200, that $100,000 gain is yours without any further tax. If it's an investment property, that same gain will be taxed at your marginal rates. So that's the considerations with respect to the unit. With respect to the business, it's another thing entirely. So the first thing to look at is how much it's netting. What are you earning? Because that then drives the tax considerations in terms of what's the appropriate structure for you in relation to the operation of that actual business. If you're netting $1 million, I would say I've never seen someone buy a business in their own name at that level of income. If it's netting $30,000, you might not want to bother with a corporate trustee or a family trust or a unit trust or a partnership agreement if you've got external investors or otherwise. So that's the tax component, and that's also coloured a little bit by what your previous history has been. You might be rolling a capital gain from a previous active asset, be it an operating business, into this one. And as I'm speaking today, those laws allow you to defer capital gains tax if you continue to roll that forward, again, subject to your accountant's advice. From a lawyer's perspective, we come at things slightly differently. Because we're not accountants, as much as I might know a little bit about how tax operates, I don't give advice on it. From a lawyer's perspective, we're more about asset protection. And the ultimate way to protect assets is to not have them in your own name. That might be owned as a company. It might be owned as a trustee of a trust. You might be the personal trustees, or there might be a corporate trustee. All of these things have to go into the mix in terms of where you've come from, what you're actually wanting to do in terms of protection, and how you might actually split the risk and split the asset. But I suppose the important thing at this stage is those are all questions to ask your right advisors when you've actually found the type of business that you want to buy. You won't need that structure in place as you sign an offer and acceptance, which is really just a one-page document to sort of indicate your willingness to purchase that particular business. But you will need them all in place with everything allocated before you sign the formal contracts, because if you don't have that, you may be liable at double stamp duty. But usually there's a window of maybe 3 days to a week between that offer and acceptance and the signing of a contract to put all those things in place. So in the words of a former Prime Minister, it's be alert, not alarmed. Be ready to have those conversations and maybe know what they're going to be, but you don't need to press the button to incorporate those things until you've actually found the business you want to buy. Let's talk about the offer process for buying a management rights business. Like any real estate investment, it involves potentially a little bit of to and fro between yourself and the seller, usually with the broker intervening in the middle to help parties meet minds in relation to what the price is. Ideally, if you've been scouting around in the market for a while, you should have an understanding about what the real value of the business it is that you're looking at should be. And the broker will normally help you navigate that and potentially manage the seller on that to the extent that the seller's expectations are unrealistic. When it comes to documentation, it can be done two ways. Is the offer and acceptance process might be done purely via the broker via phone. I'm happy to pay $1 million. The vendor wants 1.2. I'm coming up to $1,050,000. The vendor's down to 1.1, and maybe that's where you meet your middle ground. Occasionally, it's done backwards and forwards on a single piece of paper that isn't legally binding by any stretch of the imagination, where amounts are changed, reinitialed back until there is a meeting of minds. It's important to note from a legal perspective is that that single piece of paper is not going to be binding. It's more an indication of everyone's intentions as opposed to a binding legal document. So don't sign formal contracts before you actually get legal advice on them to make sure that all of the terms and conditions that need to be taken into account are taken into account in the contract, and you'll know that that's the case by all of the disclosure and the multiple pages of legal documents you'll be asked to sign. So that offer and acceptance process is usually a little bit of to and fro and depends to a degree on where the market is at the time. If the market's particularly buoyant, interest rates are really low, everyone's moving to Queensland, then you might need to make a quick decision and pay a lot closer to the asking price. If we go back to, I'm showing my age here, the GFC in 2009, where buyers were very thin on the ground and there were lots of listings, then you can probably be a bit more flexible in terms of where your offer might be. But ultimately, the decision about what you want to pay is completely up to you. It should be hopefully informed by you scouting around the market before you've actually made an offer on anyone. And if you're really not sure, most contracts are subject to finance, and to the extent that you want it, you can ask your bank to conduct a valuation from a formal registered valuer to make sure that what you're paying is consistent with what the business is actually worth. So there are some checks and balances along the way, but don't be afraid of that one piece of paper. Let's talk about signing the management rights contracts. So once you've agreed terms with a seller or via an offer and acceptance of some form, it's up to the seller to prepare formal contracts that reflect the deal. So if you're buying a piece of real estate as well as the business, they'll be on two separate contracts. They'll be REIQ contracts usually, and they'll be linked. So one will deal with all of the property aspects of the purchase, the other will deal with all of the business aspects of the purchase, and they'll be conditional on each other being signed and conditional upon each other being settled. So you don't buy one part of the business without the other. Of course, if you're buying just a business only, there'll just be a business contract and there won't be reference to any real estate. Occasionally we get multiple deals where you might buy two businesses from the same vendor with two bits of real estate. If that's the case, then there might be 4 contracts, 2 units, 2 businesses, and they'll all be linked together. So the main thing is at that very initial stage is that everything stands or falls at the one time. Now, most of our conditions precedent that are what the deal's subject to are contained in the business contract. So for example, because the contracts are linked, you won't necessarily have a finance clause in the unit contract because there's one in the business. So if the business contract comes to an end because of that linkage, so does the unit contract. So you don't need to have them tied in together. The unit contract might include things like being subject to a building and pest inspection. It might include it being subject to the body corporate approval of the keeping of your pet. It's really down to your individual circumstances on that one. The business contract is where most of the meat is from a legal perspective. That's where it will set out what the business needs to net from a financial verification perspective and set a date by which that's got to happen. It will include the legal due diligence provision, which gives us the ability to go through the business records and make sure everything is what it should be. If you need to borrow money, it'll be subject to finance, which means that it's subject to you getting a letter of offer from a bank of your choice on terms and conditions satisfactory to you that you've got enough money to buy the business with the equity you're contributing. The final piece of a management rights contract is the body corporate approval. So every management rights deal is subject to the committee approving the assignment of the management rights agreements to you. So there are an enormous amount of checks and balances on the way through what we call the due diligence process, because in management rights there's no cash. It's through a trust account, it's through a body corporate salary. Those things are all verifiable. So, and we usually stagger these things so that the figures might be 14 to 21 days from the date the contract's signed. The legal due diligence is probably then 21 to 28. Finance approval might be 45 to 60, subject to how much you're borrowing, what other security you're putting up, and what your financial position is. But either way, if any of those conditions are not to your satisfaction, you get to terminate the contract or contracts, get your deposit back and walk away. Now, you will tear up, in a sense, whatever the investigative costs are to that point in time, but that, in a sense, is a small price to pay if you're not happy with what it is you're being asked to buy. So it's a very structured process. They're very comprehensive documents, and you absolutely need to make sure that you get legal advice before you put pen to paper on those to make sure that what you think the deal is reflected in the paperwork itself. Now let's talk about the financial verification. This is where your accountant requests information from the seller and goes through all of their books and records to make sure that what you've been told the business is earning, it is actually earning. So there's two parts of the income that the accountant's going to be looking at. The first is the caretaking salary. That's the remuneration that's paid to you by the body corporate every month for the performance of the caretaking functions on the common property. You know, pluck a figure. If you've got $120,000 plus GST salary, 10 grand plus GST will hit the seller's bank account every month. So that's the first thing the accountant will look for. The second thing is the rental income, the management fees and the like. Now, all of that is going to be verified by the accountant going through the vendor's trust account. So they will see the rents coming in, they will see at the end of the month what has gone out to owners and what has come to the seller of the business. And collectively, that is going to make up the revenue side of the business. The accountant should then look at what the expense side of the business is going to be. So that's going to include things like licenses. It's going to include some repairs and maintenance potentially in terms of profits and losses. It'll include audit expenses and those sort of things, because revenue is one thing, expenses are the other, and the bottom line is then the net profit based on what a two-person management team can do. So the standard management rights contract doesn't allow for the removal of salaries that Mr. and Mrs. Smith would otherwise be paid for the performance of that work. So in a lot of times, you effectively buy yourself a job. Now, the assessment of what salaries or what staff are needed for a business can be a very subjective thing, and your accountant should and normally will look at that. They'll also look at a bunch of other things for outlying trends with respect to the letting pool. They should look at the letting appointments to make sure that they're all there, they're all signed, they're all assignable. Good accountants will confirm that the charges that the seller has been levying or rendering against the owners in the letting pool are consistent with the letting appointments that the seller has with each of those owners, and all that sort of stuff. So what you should get at the end of the day will be a report from the accountant that sets all this out. And from our perspective, there might be one or two things in there that we need to look at from a legal side of things. So for example, something that's becoming increasingly common, particularly in high-rise buildings, is the provision of internet services to owners and occupiers, so both owners and tenants. Those services are usually provided by the on-site manager entering into an arrangement with a third-party provider that effectively delivers pipe to the front of the building, and then people can come and go via software and hardware that's installed in the individual units in the building. If the management rights business has that sort of income, it's important from our perspective to make sure that it's documented properly with the body corporate, and that when you're buying it, that you know it's going to be recurring. So while the revenue piece and the expense piece might be part of the accountant's job, making sure that it's going to be there on an ongoing basis can become ours. So those are the sort of things that your accountant should look at. The last thing is to make sure that if you are borrowing money, that you don't necessarily use your local accountant or your long-term one, because the banks can be pretty finicky about making sure that they've got a report from someone that knows what they're doing. So if you pick an accountant that is, for want of a better phrase, outside the circle, you might have to go back and get the verification done again, because your bank won't trust what your accountant produces. So make sure you ask your accountant before you engage them for this particular purpose that their report is going to be acceptable to your proposed financier, because if not, you need to consider who you're using there and then. But if they are on the panel in a sense, all good. So let's talk about the legal due diligence. What actually happens? So I think probably in every management rights purchase you should get one of these. Now clearly that's a little bit subjective because that in a sense means more money for lawyers, but it's the biggest variable in the process. You might be comfortable with the figures, you might be buying a caretaking only business where you need to look at just at the salary. You might have the complete purchase price in your hands, in which case you don't need to borrow, so you don't need finance. But from my perspective at least, the legal due diligence is one of the most important parts of the purchase process, because the reality is what you're buying when you're buying management rights is it might be a piece of real estate, and that real estate is valued like any other piece of real estate, square meterage, presentation, size, etc., but you can touch and you can feel that. A management rights business, in effect what you're buying is the ability to continue to earn the income derived by that business that the seller is telling you is there. So if you're buying a business worth netting 300,000, you want to know that next year the basis for that 300,000 is going to be there, and the year after, and the year after. With management rights, the basis for that income is based on the validity of the management rights agreements themselves with the body corporate. So if those agreements for whatever reason are invalid or don't exist, or an option term's been invalidly granted, then the ability to earn that income might not be there. So for me, the single biggest thing with a management rights due diligence is making sure the agreements are valid. Now, inside the legislation and the body corporate minutes and the bylaws, there is acres of detail that we go through to make sure that you're aware if there's any legal issues, but also aware of any commercial issues. So a legal issue, for example, might be, just so you know, every management rights agreement or variation to a management rights agreement to add further option term needs to be considered by secret ballot. There's a very structured process for how that has to happen in terms of where ballot papers need to go, where they're sent back to, how they're held and how they're reported on. And if it's not done by secret ballot, it's invalid. Black, white, end of story. And that particular agreement or variation is all over. So that's obviously a fairly important legal thing you need to be aware of. Inside agreements though, there's multiple other issues that can pop up. There might be uncommercial terms in relation to assignment or termination. There might be ridiculously strict office hours where someone must be in an office from 8 till 5, Monday to Friday, 5 days a week. And that's not necessarily factored into the salary. There might be a myriad of issues between the seller and the body corporate, where the body corporate's gone and commissioned a performance review. So if those things are happening, you need to be aware of them, and you need to know that when you're making the decision to proceed about how you actually proceed. So multiple ways to deal with those then too. So the first part is identification of the issues. The second part is how you deal with them. So that secret ballot example, there's no other way to deal with that than go get a new agreement, because the previous one doesn't exist. With respect to a history of dispute between the sellers and the body corporate committee, you might look at the makeup of the committee, and we might say to you, you know what, before you go further, maybe you should go have a sit down with the committee and clear the air on some of these issues and find out whether it's the seller's problem or whether it's the committee's problem in terms of the creation of this particular relationship. And those sort of things are the things that we will guide you through from a legal due diligence perspective, so that you really, for want of a better phrase, know exactly what it is that you're getting yourself into when you buy the business. Now, if it's squeaky clean and there's no committee and it's a nice neat 25 years and there's no owner-occupiers, then happy days. Maybe there's nothing more, but maybe there might be something. And I suppose this is where the years of experience come into it. So at any given point in time, we'll have somewhere between probably 10 and 20 individual management rights transactions on foot in our office. So all day, every day, we're dealing with things as they pop up. And there's no excuse for not taking advantage of that type of experience from your perspective or for ours. So this is a really important part of the process. And it's also really important that you read what it is that we give you. Yes, there will be paperwork, and there's always the caveat that we get taught very early at law, is that sometimes there might be something in an agreement that to me doesn't look bad, but to you isn't consistent with what you've been told. So if there is something like that, you need to read the agreements to be able to tell us, because then we can deal with it. Because you have an ample opportunity to go through everything, and you need to make sure that you do. So let's talk about your finance approval. From my perspective as a lawyer, it's probably a lot simpler than what it is going to be from yours. So what I want to see at the back end of the process is a letter of offer from your bank saying they're going to lend you X dollars at X rates of interest with X fees and with X conditions. So then I know for sure that you've got the ability to complete, and that if any of those conditions require things to be done before you settle, that we know what they are and we can deal with them. So the two conditions that might often pop up more than anything else, it might be subject to the bank getting a valuation that's satisfactory to them, or it might be subject to their lawyers doing their own due diligence. So each bank has its own separate policies and its own separate needs in relation to what it wants from people that are borrowing money from it. So where a bank doesn't need a legal due diligence, it will always accept our certification in a pre-agreed format to say that everything's okay. But sometimes, subject to how much you're borrowing and what your history is, they might want their own bank to look at things. Now obviously the finance approval process from your perspective is going to be completely different, because you're going to be going through 100 points of ID, provision of tax returns, assets and liabilities, potentially valuations on other properties, previous business, investment, personal, financial history and so on. And the main thing from my perspective is that you give to the bank what they need the moment they need it, because they are, not always, but usually, ponderously moving beasts with lots of activity going inside, and they're very structured in relation to the processing of the information that you give them. So if you give it to them in dribs and drabs, we'll be delaying the date by which you're going to get finance approval under the contract. If you give them everything they need at the one time, ATO portal balances, all that sort of stuff, it will make the process a whole lot easier from your end and allow them to produce the letter that I need to see that makes sure that I can say to you, from my perspective, that's completely standard. If you're happy with it, let's go and move to the next stage of the process, which will usually be body corporate approval. So from a bank's perspective, give them everything you need, or everything they need straight up, and then answer the questions as they've got them, and that should create a more seamless finance approval process. So let's talk about the body corporate approval process. This is one of the biggest variables in any management rights transaction, primarily because you've got a whole bunch more moving parts, which is people. So a body corporate committee can be up to 7 people, and normally you're going to have the body corporate manager involved, and potentially all of them might want some sort of say. So there's 2 components to this. The first is what you've got to do. Now, a body corporate interview in this context isn't like a job interview where there's 15 applicants and they're going to pick the best one. There's only one applicant, and it's you. So the body corporate also can't unreasonably withhold consent to the assignment. So to me, in simple terms, what that means is they've got to say yes unless there's a really good reason to say no. And so a good reason to say no might be that you were convicted of trust account fraud 12 months ago. To me, that's a bit of a no-brainer that would allow a body corporate to refuse consent. But beyond that, it gets harder and harder. So, but just because it's not an interview with a whole bunch of applicants doesn't mean you shouldn't treat it like one. I think we get the best results for clients when clients go into this meeting preparing as if they are applying for a job, and the body corporate has complete discretion about whether they approve them or not. So to me, that starts with a very professional first presentation. So your resume should give all of the information that you normally would in a job interview: your history, where you've been, what it is that you're trying to get out of that business, why you've decided to buy it. Ideally, it includes a couple of references at least in writing. So that's not call Frank Higginson, here's his phone number. That's a written reference from Frank Higginson saying, Richard's a great guy, I've known him for 15 years, works really well with people, blah, 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 blah. So that it makes it really easy for the committee to get a handle on what it is that you're asking them to read. They don't need to do any more work. The other part, and this is a little bit invasive, is the body corporate's entitled to evidence of your financial standing. Now, to me, the only real way to prove financial standing is a statement of assets and liabilities, but lots of people obviously don't want to actually produce that. So maybe in the first instance, you might not put that forward, or you might get something from your accountant to say that you're financially capable and solvent and will be able to run the business and so on. But again, these are all things that we can walk you through as we get to this stage of the transaction, and we'll certainly, if we're your lawyers, provide you with some templates that you can use for preparation of these documents. And sometimes the management rights brokers, if you've got a good one, will help you work through that as well. Because you only get one chance to make a good first impression, and the first impression is when you meet that committee. From the seller's side of things, it's for them to be able to prove to the body corporate that you can do the job. So ideally, you provide them with all of the information. The seller, in a sense, goes into bat to say, hey, sold the business to Richard, here he is, really good guy, blah, blah, blah. Now, this is where one of the biggest variables come in. How the body corporate treats you as a buyer will depend on their relationship with their seller. Now, this is a bit awkward at times. Sometimes you can be the meat in the sandwich, where if the body corporate has had a really difficult relationship with the seller, where there's been performance management issues and whatever else it might be, that committee is naturally going to be a bit more wary of you, in the sense of, are we jumping from the frying pan into the fire? Are we going to go through this same grief again, or whatever it might be? So ideally, you're armed with that information from your due diligence, where you've read the body corporate minutes and understand what the mechanics of the relationship actually are. The alternative, of course, is where the manager runs the show. There's a very much uninvolved committee who let the manager do what it is, and they run that with the Strata manager. And if that's the case, then you'll probably seamlessly sail through the interview and assignment process. Sometimes there might not even be an interview. It all just depends on really the people on that committee and how their relationship with their current manager is. So I think with that, it's just a matter of being ready. It is a matter of preparing professionally no matter what, and making sure you put your best foot forward. And if you think there are things that need to be addressed, then address them. So for example, a recent one we had was the manager wasn't required to reside on site. They weren't residing on site. Our clients buying are going to reside on site. The first thing we told the committee is, hey, we're going to move back on site and run this business. And from that point forward, the interview was absolute no-brainer. That's all the committee wanted to hear. So that might be your situation or it might not, but either way, it's a matter of being ready, being prepared, and putting a really professional foot forward, and you'll usually find that'll get you the best outcome. So let's talk about the settlement process. Like any property or business purchase, there's a whole bunch of moving parts that come together on the day. Your moving part, particularly if you're buying real estate, is probably going to be arranging removalists, cleaning up where you are, arranging to get in, organising power and gas, phone, whatever else it might be that you need to do. From a back of house perspective, there's some other things though that come with a management rights business. We as your lawyers will do the usual adjustments that you would in relation to the property if you're buying one. So adjustment of rates, adjustment of water, adjustment of body corporate levies and all that sort of stuff. From a business perspective though, there's a couple of other adjustments that you need to be aware of. The first is the body corporate caretaking remuneration. Subject to what date you're settling and what date the vendor was paid through, there might be an adjustment in your favour or their favour with respect to the remuneration for the period in which you're in possession of the business for which they've been paid. We'll normally do that as part of the settlement proceeds. But there are a bunch of other adjustments from an operational perspective, business-wise, that will need to be dealt with. So for example, if you're buying a business that includes a whole heap of rentals, the vendor may well have charged management fees for periods after you're in ownership of the business while they were. There might be relet fees that are being charged in advance for tenancies that haven't yet taken effect, and so on. So what we'll do is we'll make sure you understand what those actually are. And what we find is usually works is that either the vendor's bookkeeper or your potential bookkeeper will help come in on the day of settlement and rattle through all of those so that you do the pluses and minuses to make sure that everyone's paid for the work that it is that they're doing. There's also the period of training. So each management rights contract is different. I'd say the industry standard is probably 7 days before and 7 days after settlement. Usually you'll find vendors are more committed to training 7 days before settlement than they are after, because once they've sold, they can be a little bit off with their next stage of their life. So you want to make sure you arrange with your seller, ideally a week or two before the training would otherwise commence, what time they want you there, how they want you to be there, comings and goings and so on. And if you can, the perfect world is doing an end of month with them. So even if they come back and do an end of month after they've settled, just seeing how that process works is always handy. But again, bookkeepers sometimes can actually assist in that respect as well. From an operational perspective, there's some other consultants out there that provide on-site training services too. So if you don't think the vendor is necessarily going to give you the best handover or the best training, then maybe engaging one of those consultants might be worthwhile to really give you the rounds of the kitchen about what they think you need to be doing with respect to the business. So there will be a lot of moving parts. We'll manage some of them, you'll need to manage some of them, and what I can say to you though is the first 3 months will be a blur, and after that it'll get easier. But that first couple of weeks after settlement, where you don't know what's going on, can be a little bit stressful. We'll send you some material that'll help with that after settlement if you've engaged us as your lawyers. But it is a matter of making sure you will get through it. You've just got to keep grinding away. So I can't help you anymore, but other than with that little bit of advice. So hopefully you've settled, the dust has settled on the purchase, 3 months into your business, you completely understand it. What do you do now? Leaving aside making sure that you're running the business as efficiently as possible, there's probably a couple of things. One is to make sure that if you're going to change what the vendor is doing, that you manage people around those changes. Because people don't necessarily in Strata understand how these businesses are run or what's required in the running of them. So if you're going to change a process, make sure people know why. The other thing is to make sure that you know who's who in the zoo. Because it's a really important part of management rights is people. The people relationships and people management. So inside a Strata scheme, usually the most important person is going to be the chairperson, followed by the other committee members, followed by the body corporate manager. You want to know who each of those are, and ideally have a personal connection with them, because sometimes things will go wrong. That's the reality of it, that's life. So you want to have open lines of communication from them to you and you to them, so that you don't need to engage in any paper warfare down the line and arguments about he said, she said and all that sort of jazz. You're having conversations with your chairperson about the need for the pool filter to be replaced or the lift to be serviced, or Joe Bloggs in unit 33 that's smoking in the backyard when he shouldn't be, and so on. So you just got to keep driving those things continually. If you haven't or didn't do it on the way in, maybe you want to go at look at getting your full licence. It's good continuing education. You definitely should become a member of ARAMA. If that didn't happen as part of the process, then go and become a member of ARAMA straight away and start to network with people in your branch. So be that Brisbane, be that Port Douglas, be that Gold Coast. The reality is that management rights is a very collegiate industry. It's not really a competitive one. So the thing that you can be sure of is that whatever issue you're going to face in your building, it won't be the first time someone else in ARAMA has dealt with it. They've got a really good management team, but your best resource is your fellow managers around you that ideally you meet at ARAMA social functions, at branch gatherings or on committees or otherwise, because that level of interaction and cooperation in a management rights perspective is really quite extraordinary. It's one of the most collegiate industries you can find. You want to make sure that you keep up to date with what's going on around your area, and you also want to make sure that you start to build relationships with all of your owners, not just people in your rental pool, because ultimately everyone at some stage is going to sell their piece of real estate for whatever reason. It might be lifestyle choices, it might be illness, it might be financial stress, might be change of life, or whatever it might be. And you want to put yourself in position A to be part of that process, because if they sell to an investor, you want to be able to pick up the management of that property afterwards. And if you go and get a full license or get access to someone else's full license, and there's one or two operations out there in a management rights sense that provide that sort of support, you might even start selling real estate inside your scheme. So I suppose in a sense there's a world of opportunity there as long as you keep your eyes open and keep engaging with people around you, because it's a continual learning journey, and it's important that you make sure you stay on the ball, but that people management and people relationship will be the most important skill set you can work on in your time in management rights. So good luck. So that's it. So that's probably 30 years worth of experience distilled down into 30 minutes worth of conversation. And obviously there's a lot more with it. But if you are interested in management rights, you should make sure you read our guide that we published for purchasing a management rights business, because there's obviously a lot more detail in that. And of course, if you need any help at any time, just reach out to us. You want a quote for buying a management rights business, you've got a specific question or otherwise, just hit us up. So I hope this has been of value to you, and I honestly hope you find your way into the management rights industry. It's a great industry, it's been around for half a century, and it continues to thrive. So good luck with your journey, and I hope at some stage we run into each other.